We are going on the record. If you want to talk, please go outside.
Judge,
Hold on. So we're on the record. It cause number 253-4377, 2505-146. I think that's all we have here, right?
Yes.
Yes. Okay, so guys, for the record, please announce yourselves. State.
Anna Eady, EADY, for Mr. Wiggins.
Nathaniel Meunier spelled M-U-N.
Right from the start, you can feel the tone shift in the courtroom. When the judge says things are going on the record, it means every word now carries legal weight. This isn't just routine procedure anymore. It's the judge establishing control of a hearing. And when multiple defense attorneys appear this early in a case, it often signals that the issues being discussed are serious. For the defendant sitting there, this is usually the moment when the situation starts to feel very real.
IER, also for the defense.
So hold on, before you get into anything, state, you wanted to bring something to the court's attention.
Yes, Judge. So we had received a call that Mr. Wiggins was in violation of the protective order that was in this VPO, and that he was reaching out to the complainant witness in this case. We have checked the jail calls. Those jail calls show that since March 24th, which is...
Then the numbers come out, and they're hard to ignore. Nearly 300 calls from jail isn't something that happens by accident. Legally, repetition matters. Even when there are arguments about bond conditions or confusion around orders, courts tend to focus on patterns of behavior. When something happens over and over again, the question of intent starts to become much harder to dismiss.
Of course, after the October VPO, since just March 24th, we have 293 calls made to the complainant's phone number. Just yesterday, we had, I believe, 28 calls to that number as well.
So in one day, you're saying he made how many calls?
So yesterday, he attempted 28 calls to the complainant's phone.
So, Judge, I'm going to preface this conversation with, Miss Eady texted me about 10 minutes ago, so I came up on short notice on this. But my understanding is that there's no longer a protective order in effect, because it's been long enough. There's
a court order for him not to have any contact with her.
Are those part of his bond conditions?
Yes.
My client's not on bond.
Well, he is not supposed to have any contact with her whatsoever.
I understand, Judge, but the way that this court and other courts in the county have structured those conditions have been bond conditions, which my client is not on a bond. He is in custody. He has not broken.
I have ordered him, even though he's in custody, not to call her.
I understand, Judge. Assuming that he had violated some form of a court order that is not a bond condition, I believe the appropriate remedy would be contempt, and which would be a separate criminal proceeding. At the same time, for Ms. Eady talking to me today, it sounds like that the court was going to order ag-seg in the jail, so the formal...
The only way that we can revoke phone privileges on someone is ag-seg.
Yes, Judge. My issue with that is it's a hammer when a scalpel is needed. So while I understand that the district attorney's office has alleged that my client is called a victim in this case, there's no protective order in place. The bond conditions are not in effect because he's not on bond. Thus, no crime has taken place. And third to that, Judge, if he's to move to ag-seg, he would not be able to make any phone calls, not just to the victim, but anyone, including counsel, which while we are here on a misdemeanor, he is in custody on a felony and relatively serious felonies. And not being able
okay. I understand your plight.
Yes, Judge.
But there are other remedies for you to be able to communicate. Letters, in person. But the only way for me to be able to ensure that the complaining witness is not called is to put him in segregation. That's the only way.
Judge, the problem is nobody would be able to call, including our office as well as his felony attorneys. Letters through the jail are notoriously slow. A letter to my mother, who lives in the same city, takes 4 days. And in the jail, you're taking over a week.
I'm willing to put him on the docket one time a week so you guys can have contact.
Which the problem is, Judge, we would no longer be able to have any form of private contact, and that would only take care of the misdemeanor and not the felony. And not to be impolite, Judge, him having conversations with us are saying, hey, what's going on with the felony? And any jail visits that take place in ag-seg are actually recorded. They're notified by counsel going through the door that those calls are being recorded.
I don't have any other option to not prevent
Judge,
phone calls.
This would violate my client's 5th, 6th, 8th, and 14th off the top of my head constitutional rights. Right, self-incrimination because every conversation is going to be monitored going in and out of the jail because they're going to be recorded via jail visits. He will no longer be able to have private visitation inside the courthouse.
You can pull them out. You can have private visitation in the rooms
It's
there.
not about me, Judge. It's about felony court is a serious issue. But that's the
Why are
thing.
you worried about felony court?
Because that's why he's in, Judge. Then
Well,
that's
it's also in because of ours. Our bonds are at $60,000.
I understand, Judge, but the reason that this is taking as long as it is and it's been taken as serious as it is because he's in custody on a felony. And this court making him to where he cannot participate fully with counsel is...
There are other means for you guys to participate, but I've ordered you not to have contact with her. You've called her now over 300 times. I don't understand why you guys aren't filing additional charges anyways.
Sorry, Judge, I missed the last statement. I'm sorry.
The only way that I can prevent him from making 300 phone calls is to put him in another wing.
I was going to talk with the DA, and obviously, if my client's making these calls, and that's an if, he's dialing a single number, the jail's numbers can be easily blocked. I've done it on my cell phone numerous times when I've changed cell phones. Over the weekend, last weekend, I had 15 jail calls from one client. And as annoying as that is, it's very easy to block it on your cell phone. And I assume the victim could do the same. I have not heard anything from the state.
Tell the victim what to do, Nathan. I'm not going to say, can you please block your number so we can't call you?
The least restrictive means, Judge, strict scrutiny dealing with constitutional rights.
No other way to prevent him from making phone calls. I have acquiesced to you guys before and I have admonished him before. Please don't. We put you in seg last time. You were there a month. You came here begging and pleading. I'm not going to do it. I'm not going to do it. And now we have 300 phone calls. So I don't know what else to do. But now back in AgSeg.
I'm going to sprinkle the word allegedly to the phone calls because it's the kind of thing where records would exist that have not been provided to the defense by the state.
Do you have the records?
Well, I mean, I have them. I just have to get I have to do the form to get them up with the forms. Yeah.
Okay, so let's set up a formal hearing because I don't want. You're right. I don't want to give you state the benefit of the doubt without him actually or Anna actually seeing it and seeing that the phone calls were actually made. So let's set up for a formal hearing. How soon can you get him the evidence?
Instead of immediately escalating the situation, the judge decides to pause and take a more controlled approach. There's no immediate punishment, but the court introduces a sworn affidavit that changes the stakes moving forward. From that point on, any further violation won't be seen as a simple mistake. It could be treated as contempt of court. In other words, the judge is offering one final opportunity to follow the rules before the consequences become much more serious.
I'm trying to think about last time that I got killed. It could be tomorrow, it'll be a few days. So, I don't know who wants that off next Monday or something like that. I think I should have it by then. This week is the point for that. Actually, she's not going to spend those places.
And if we could keep him in normal population so that we could visit him, as does his felony counsel, and they could
Wiggins, have you signed an affidavit today promising me you're not going to reach out to the complaining witness in this case by any means? If you do, I can have a contempt hearing, and every single time it's punishable by up to 6 months in jail and a $500 fine per the advice of your lawyer. Because he thinks this is the correct avenue instead of AgSeg. Do you understand?
No.
Don't contact the complaining witness. Don't use anyone else to contact the complaining witness. Don't use anyone else's number to contact the complaining witness.
I'm going to rephrase what he just said. That means calls going through third parties. So if you call mom and have mom call her, that's against the rules. If you call mom and have mom forward the call, that's against the rules. Etc.
Yeah.
Okay.
This is the affidavit that you're going to sign promising me you're not going to contact her or the complaining witness in any of my misdemeanor cases. Do you understand? Okay, so you want to set it for Monday? Okay. But just get it as soon as you can, get it to them. Have a hearing on Monday to see whether he's actually making the phone calls that we ordered him not to.
This is you swearing that you will not make these calls.
And let it be clear that I truly have no least restrictive means than to deny his ability to make phone calls to the complaining witness. There really is no less restrictive means.
Judge, my understanding is that the jail can prevent Mr. Wiggins' SPIN number from calling him.
In the last time, he used someone else's SPIN number to make the phone calls.
And what's that?
So,
Yeah.
well, we'll see this time. I don't know. Okay, all right.
Just for the record, Mr. Wiggins, I want you to make this aware that this is the court having you swear, which is legally binding, that you will not be making any calls. And if you violate this sworn oath, then that is punishable under the law. You understand?
Sure.
Okay. Thank you, Judge.
Judge, I forgot to approach you on this other case. It's Miss Loyola. Judge, she has an AFM in our court, but she has a felony.
So she's on bond for an assault of a family member,
Yes.
on bond for a felony assault of a peace officer, and now you pick up a new case.
And what happened was she went to felony.
Oh, hold on. I don't even think we've done probable cause yet. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You now stand charged with possession of marijuana. You're facing up to 6 months in jail and or $2,000 fine.
Thank you, Your Honor. On March 19th, 2025, a law enforcement officer observed a white Chevrolet Silverado ahead of him on the block 12600 block of Wilcott Parkway and ran the license plate through the NCIC TCIC. Registration was shown to be expired as June 2024. A traffic stop was initiated and the law enforcement officer made contact with the defendant, the driver. The law enforcement officer observed a strong odor of marijuana, and the defendant claimed at first she didn't have anything in the motor vehicle, then confessed she had marijuana and several pipes. The defendant was detained. Probable cause search of the motor vehicle was done, and the law enforcement officer located multiple marijuana pipes. The law enforcement officer located a small bag of a leafy green substance and a black bag in the back seat. It was identified as marijuana, and the bag was within arm's reach of the defendant. Total weight of the marijuana was 0.09 ounces.
She has a license.
Yes, Your Honor. It does show be
Eligible or
ineligible.
ineligible? Not allowed to drive. You will now be signing an affidavit with me today promising me you're not going to drive. I don't give a rat's behind what your excuses are. If I find that you drive, I can have a contempt hearing. You can be facing an additional 6 months in jail and or a $500 fine every time you drive. You are on bond for 2 cases. Your first bond violation report was filed in February for you not showing up for testing and not picked up a new case. I now revoke your bond on the assault case.
Judge, if I may,
Please.
she went to felony court, and she was also revoked there. She just spent probably 4 or 5 days there. Is that
Yeah.
right? And she's out here, so.
The day that moved was I was in jail for a traffic ticket and a
The-
big call.
I don't know if you heard that, Judge, but the day that she missed court here the first time.
No one ever missed the
You
test.
missed it, that's right. She actually had texted me and she got taken into custody because of a traffic ticket. I have all that. So she was actually on her way to the testing and got picked over, and therefore she couldn't continue to make it there. So she's already been punished for bond revocation on the felony court, which she spent 5 days in jail last week. When did you get out on that?
Saturday.
Saturdays. And so if we take her in, I know you have a right to, Judge. It seems to me like it's kind of like a double whammy for her, especially for the fact that for that first BVR, she did honestly try to make an attempt to get there. I have the phone records for that, Judge.
When someone tells me something and they repeatedly fail
to recognize the conditions that we set forth. For me, it goes in one ear and it goes out the other ear. You telling me something is, when you get out the doors, you still do whatever the hell you want to do without regard to bond conditions in this court. I'm now revoking your bond. She goes with you. Well, hold on. I need to sign this affidavit so she's not going to drive. And then she goes with you. I'm sorry,
Can
John,
I-
but it's just one thing after the other. Just
Do you want to
too
go
much
ahead and just issue a new bond, or can I revisit you in about an hour to figure out what we want to do, Judge?
drama. Sure.
You want to do it that way? Okay.
Keep it down, we gotta play.
She did, or will we have to wait till you give Mr.
Well, hold on a second. Hold on a second. You really want to do a probation with Mr. Proctor?
That's what he said, Judge.
You couldn't even stay out of trouble while you're on bond. Why do you actually think that you can make a probation? Yeah, I've heard that before. How many times have I heard that before? How many bond violations have we had, Mr. Proctor? You know, you can lie to me, but you can't lie to yourself. You know, if you think you repeatedly fail to appear for court, you repeatedly fail to comply with bond conditions, how on earth do you think that you're going to be able to make probation where you have to do classes, you have to remain clean, you have to report once a month? You can't even report to court once a month. How are you going to do this for 12 months? History says otherwise, Mr. Proctor. Can we do a TRAS on you? Before I do anything, I don't know how to go forward with him. And I think that probably the best way to see is to have Mr. Proctor evaluated to see what conditions and what is the appropriate way to go forward, because I have no idea what's going on in your life. I have no idea what you have, and we don't want to see you fail, Mr. Proctor. We want you to leave better than you came. But just doing this right here, it's just throwing you out there to the wolves. I mean, if you really think that this is the appropriate way, you can even, while you're on bond, for a couple months, stay out. Before, I would like to have him evaluated. So what we do is we have clinicians available that can interview you, talk to about you, what's going on with your life, what has been happening with you, how everything has transpired and how we've gotten here to this point, and to see what's the best way that we go forward. Do we need a treatment plan? Do we need inpatient treatment? Is it sufficient to do out? I don't know, but I'm not ready to do this just yet. I think that we need to have the TRAS to see how we go forward. Let's see what they say, and then at that point, you want to court reporter regardless, right?
Oh, no, sir, no, sir. We will respectfully honor the
So let's.
request by the court.
It doesn't have to take long. I can expedite it so we can have everything done within the next couple of days. We're not talking weeks. We're not talking, so we can have everything done quick. Because I don't want you to just sit there and languish. But I need to know how to go forward. And this, I don't think that this is the appropriate way. If they say after we have you evaluated, if they say and they give the blessing, then I'm all for it. I want to do what they advise because they know best. Every time I have someone TRAS and I deviate from it, we pay dearly. So that's why I trust them to give us the best advice as how to go forward. All right? Give me a couple days. Let me get the TRAS done. We can come back and then we'll go forward. Okay?
Thank you, Judge.
Thank you, Your Honor. Just want to make sure I have it written on there. So we'll put away from TRAS before we do the plea.
Right. Yeah, because I want to know what are the appropriate conditions that we put, because this right now, this is the type of probation that we usually do when people have, no violations or, they've been, but here we have multiple, 4 different violations from one thing or the other. So that's why.
Thank you,
Thanks.
Judge.
Okay.
Yes, sir. Thank you.
Hey, Your Honor.
Sheila.
I'm approaching on Mr. Portillo Sanchez.
Judge, was presumptively positive for alcohol, fentanyl, and cocaine use.
Your Honor, he wants to take a plea for 180 days today, which he's got 22 days credit, so.
I don't know.
All
I
right.
mean, I think the last time we had said a year, right?
We set it for trial, I think, on the 22nd-ish, and he wants to plead to 180. No, okay. Will you, is there anything the court would accept? No.
I mean, I'm over and over and over. And I don't know if that's what it is that's causing everything in all these cases. But I have a sneaky suspicion that it could be due to all that. You now tested positive for cocaine, fentanyl, what else?
An alcohol, Judge.
Alcohol. You were on bond for 5 different violent cases. Goes with you. I'm sorry, Mr. Portillo. What I would like to do, because obviously now we now know that there may be a more substantive issue that may be causing all this. So what I'd like to do is have him TRAS to see how we go forward. But I'm not going to just continue to take these cases where we're basically pleading guilty, throwing him in there 30 days, gets out, he picks up another felony. We have now 4 or 5 open felonies. No, I'm not going to continue to perpetuate this revolving door of you picking up a case, getting out, picking up a case, getting out, picking up a case, and now you're testing positive. No, we will now get to the root of what the problem is and why you have 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, now 15. It ends today. Goes with you? We'll have him TRAS. Let's see what it says. And then, you know, but I'm not just going to continue to do the same thing in hopes that when he gets out. So, send it for TRAS. We'll come back in a couple days, get the report, and let's see what they say on how it goes. Okay. But I'm not going to just continue to do the same thing and hope for a unicorn because it's just not going to happen. You know?
I would like to just,
It's up to you.
I would like,
Want to?
I mean, if,
Can,
but, right,
let's figure out what's going on.
sure. I just want to see what I mean,
Sure.
obviously as his attorney, I need
Absolutely.
to see what his options are and meet with
And I don't
him.
want you to do anything you are not kosher, or not happy with, you know? Before we do anything, you know, of course I want your blessing. And if he says no to what they say, then we just go
Have
to
a
trial.
trial.
And we'll go one after the other. Just be ready, please. Okay.
Should we, I guess, set him like for Friday or something and see, I don't know.
It's probably gonna be the process of today. I don't know if we're going to tomorrow.
No, there's no way. It's now 11:30. Till tomorrow, he's still gonna be processing. Right. So we can't start the TRAS until he's out. Latest will probably be Wednesday is when we get it done. I would say we probably will have the report.
Well, but he'll be set for bail review automatically, right? For Wednesday or?
But if he stays in holdover, somebody can come over there.
We usually have people come here to do the TRAS here.
Right, okay,
Here, to
okay.
try to expedite it so that they don't sit there for a week or
Sure.
2 weeks, you know, because we want to, it's not the idea, it's just to hold, just for the sake of holding, is to get it done quick so you guys can make the informed decision quick. And we'll see, you know, and the idea is hopefully he's honest and then try to get to the cause because,
The options.
you know, before there's a murder case because he's using and he does something that's irreparable, you know?
I
I
understand.
mean, how many times have we seen it? So, okay.
Thank you.
Tiger.
Sorry, Judge, I just have,
Man,
I'm terrible. I'm in this death penalty capital, so I just don't.
still?
Yes, Your Honor. We're 2 out of 3 weeks. I just have 4 minutes left on my bathroom break. Mr. Thomas tested, it looks like his marijuana levels are going down, but he did test positive for alcohol. I
Talk
talked,
to Mr. Thomas.
he's present, Judge.
Not only have I reinstated his bond once already, but now we're working a second bond violation warrant. What do I need to do to get your attention, Mr. Thomas? Yeah, right. Justin,
Yes,
what
Your Honor.
do I need to do? Put his butt in jail?
Um, I, I think we've been in felony court this morning, so I don't want you to think he wasn't here. He was,
I don't care
he was
about
great.
I care about him continuing to use and continuing to do whatever the hell he wants to do without regard to bond conditions. You do what you want to do. I think I have but one choice, Justin, and to just put him in jail.
Judge, what do you think about some AA meetings or some,
I don't think it'll. When did we order him not to use?
What was the last name again, Judge?
This is Thomas, Mr. Thomas.
Conditions were set in place on October 11th.
This past October, we've told him not to use.
the marijuana is negligible, so it's almost out of the system. It was at 0.005, I think. I understand the court's frustration and concern.
If it's been bond conditions since October, we're now nearly April 1st. It's been 6 months. So it should have been way, way gone.
No, it was from the positive. So you admonished him on the positive not to use, and then, so this was his first test since,
February 6th.
right, and so that's what I'm saying. So the marijuana is negligible. I know it's not an excuse, but I don't know that we read all of our bond conditions about alcohol. Now, I know that's not an excuse because he signed for it. I get it. But I do want to point out to the court that the marijuana is basically out of the system. It was like, that's why I'd asked for the levels, but it was like at a 0.05 or 0.005. It was,
Alicia, do you see that?
The levels, Judge, let me see if it's in the email.
it was, I asked for that, Judge.
I know. I saw that you did. What do you do for a living? Where do you work?
Russo's Pizzeria. I'm a chef.
What is it?
Russo's Pizzeria. I'm a chef.
He's a chef at Russo's Pizzeria, and we're in school. So we are being productive members of society.
How do I know that? Am I supposed to take your word for it?
You can take his mom's, Judge. I talk to his mom pretty much on a regular basis.
Judge, have you seen that number? However, truthfully, I don't know what that means. But it is a low number. So that's all I have to offer for, but.
Here's what we're going to do, is I'm putting a scram monitor on his ankle, so I know that he's not consuming alcohol.
Yes, sir.
I'm now going to put a GPS monitor, and I'm giving you a curfew, because I don't want you out in the middle of the night. I'm giving you a 10 p.m. curfew. If you ever have another bond violation, I'm going to revoke your bond, and I'm going to make it so high. Do you understand?
Sir.
I'm sorry.
I will test you again in 2 weeks. If you test positive for marijuana after 2 weeks, then that tells me that you've continued to use, and I'm going to lock you up. Do you understand?
Sir.
Maybe it's to go back to very important cases.
Yeah, so he's back in 2 weeks to test. If he tests positive after the 0.05 nanograms or whatever the hell it is, if he's still testing positive.
I have
then
nothing
that's
left
it.
to say, Judge.
All right.
I will be speechless.
All right.